それでは引き続きモデレーターの相良先生、氏家先生、よろしくお願いいたします。
Okay, then let's start with question number 5. This is the issue of standing to sue. Assuming that Japanese TV station A has standing to sue for copyright infringement, is Pony TV a licensee deemed to have standing to sue for copyright infringement against DonkeyNet? And first, if Pony TV is an exclusive licensee, does it have standing to sue? So this time, again, we'll try the card. Please show the cards. Please answer by showing the cards that the exclusive licensee has standing to sue, yes or no, in your country. The exclusive licensee has, are you ready for? Sorry, exclusive licensee has standing to sue. Sorry. Yes. And Arek? Okay. Thank you. Every country answered yes. Yes. So I'd like to confirm your answers in turn. So does copyright law in your country stipulates that an exclusive licensee has standing to sue? Does copyright law in your country stipulates that an exclusive licensee has standing to sue? Yes or no? The law says so. Standing to sue. Laos and Thailand, they don't have, and any other countries has that kind of law. And I'd like to, actually, I'd add the question that is it required to register the license agreement to be effective? The registration is required to be effective in your country? Yes or no? The license agreement has to be registered. Indonesia, Laos, you said that you, this is yes and this is no. Yeah, Indonesia and Vietnam, yes, the registration is required. Okay, so I'd like to ask judge from Thailand. In Thailand, your answer says that the contract is the ground. So it means even exclusive licensee cannot have standing to sue if the contract says no. So can you clarify? And what if the contract says nothing about the standing to sue?
Yes, thank you very much. At first, I would like to say that if you look at my CV in the paper, you will find that I made a thesis when I did a LLM about the licensing agreement comparing between Thailand and Japan. So it means that I studied about the licensing agreement. And from my experience, there are many contracts that the licensor does not want to give this power for the license, even exclusive licensee. So they keep it with them. So it means that even you are an exclusive licensee, you will not have the right to stand for the case. But if there are not any clause in the contract, it will be coming to for principle of the licensee agreement that the exclusive licensee will have the right to go to the court.
Thank you. 多くの契約において、コピーライトオーナーがエクスクルーシブライセンシーにもその、当事者的、訴訟する権利を与えたくないということで、それは、自分オーナーの方で保持するという内容になっている場合が見受けられると。でそういう場合には、エクスクルーシブライセンシーであっても、当事者的格はないと。その契約に基づくと、エクスクルーシブライセンシーにも認められないと。で他方、もし契約に何も書いていなかったならば、その契約の解釈として、原則に戻ってライセンシーもエクスクルーシブライセンシーであれば、当事者的格があるというのが、単位の、扱いであるということです。So how about the case in Japan, Judge Tanaka?
Okay. I think that Pony TV as an exclusive licensee has a possibility of asking the court for an injunctive relief by the licensors of subrogation right. That means Pony TV can exercise the ATV station right in position of substitution in certain circumstances, such as negligence of contract's obligation. Although Pony TV may sue for damages based on the fact that its exclusive rights are violated. My comments.
Thank you. Then how about the case for where Pony TV is non-exclusive licensee? Again, can you show the cars? Pony TV, who is not an exclusive licensee, non-exclusive licensee, have the standing to sue. Yes or no? Okay, I think. Are you sure? Right? I believe that my memo says that the Philippines, Singapore, Thailand, no. It seems that more no's here. Okay, great. Myanmar and Cambodia, non-exclusive licensee does not have standing to sue. No? Yes. No. Cambodia, no. Myanmar also, no. Okay. More no's here. So, Malaysia, your answer says that non-exclusive licensee cannot be a plaintiff, but can be a plaintiff only when it sues together with the copyright owner. Is that true?
Answer is yes. And it's important sometimes because the non-exclusive licensee could be the party that suffered the damages. So that is why sometimes it needs to sue, but it requires the copyright owner to be joined as co-plaintiff.
Thank you. ノンエクスクルーシブライセンシーであっても損害は被っているので、単独ではできないけれども権利者と共同であれば、原告になることができるということです。So how about Philippines? Is it, for example, like Malaysia, is it possible for a non-exclusive licensee to be a co-plaintiff with the copyright owner? Judge from Philippines.
Yes. he can join the copyright owner. There is a possibility that he can join in filing a case for infringement.
Thank you. フィリピンではできるんじゃないかというふうにおっしゃっています。How about in Singapore?
The answer for Singapore would also be yes. I think our reasoning would be the same as what the Malaysian judge has spoken about. The reason why I had answered no earlier is because from the question it wasn't clear to me whether or not it was a co-plaintiff situation. I thought the question was whether or not a non-exclusive licensee can on his own bring an action. If he's a co-plaintiff, then he's the one who has suffered the damage. I don't see a difficulty with that.
シンガポールでも、単独ではノーだが、一緒であれば、いいのではないかと。Do you mean that for example, the copyright owner is enforcing injunction right? Not only damage, the damage claim, but injunction right? In that case, still the non-exclusive licensee can be a plaintiff of that case?
I would imagine that a non-exclusive licensee would usually only have a relevant role if there are damages being claimed, because he is the one who might have suffered damages. So if it is a pure injunction that is being sought, I don't quite see why the non-exclusive licensee would be a relevant party to the suit.
Thank you. So you mean that the non-exclusive licensee can be a co-plaintiff even if the...
He can be a co-plaintiff, but I think his role is only relevant if damages are being claimed.
Okay. 差し止め請求権を行使してでもなれるんですかと聞いてみたんですけれども、なれるんじゃないかということのようです。So in Indonesia, Judge Unggul, I understand that your answer says that it is decided by the contract, maybe like Thailand. What if the contract says nothing in this regard?
Yeah, thank you. It has nothing to say anything about that in our articles. As in, like, Indonesia is continental country, so everything will be based on that. If you, like, Judge Lim from Malaysia have put it like, yeah, in the benefit of the wholeness of the case, it would be better to put the original author of the copyright. But without it, you can. It's like, as long as the subjective right of the licensee is being damaged here, yes, you can sue. In regarding of the clause on the agreements, it's not about per se we have to look specifically on that, but in relation whether damage has been done by the defendants toward the plaintiff. That is the judge in Indonesia, it is my personal opinion, will look into it. It's not about the clause in agreement. If it's nothing about, say, if it's like, you know, very plainly says you cannot sue, then there's no ground to begin with to the court. But if it's like there's nothing on it, then we will look into whether there's relation between the plaintiff and the defendants and what has been done.
契約に何も、インドネシアは基本的に法律で何かライセンシーの権利が規定されているわけではなく、契約を解釈することになると。なので契約に書いてあればそれに従うわけですけれども、契約に何も書いてなければ、当事者間の意思を解釈して、判断することになるというようなことのようです。これについては、And how about in Japan, Judge Tanaka?
Okay. Firstly, I would like to point out that Japanese copyright law doesn't stipulate exclusive licensee, monopolistic licensee, or non-exclusive licensee as a statutory language. And I think that Pony TV as a non-exclusive licensee can neither sue for damages nor for injunctive relief on the grounds that Pony TV rights are not exclusive. Those right holder can say something only to copyright holder, but I think they cannot demand to stop third parties and also no damages. And I think that they cannot exercise no subrogation right in this case. Thank you.
So in Japan, non-exclusive licensee can be a co-plaintiff with copyright owner?
Well, in my opinion, even if the non-exclusive licensee sue together with a copyright holder, my answer is no, no joint plaintiff.
Thank you. 日本ではノンエクスクルーシブライセンシー、エクスクルーシブライセンシーは、差し止め請求権の代行使などがありますけれども、ノンエクスクルーシブライセンシーであると、それも、ないと。で、今日他の国に聞いたように権利者と著作権者と、一緒に共同原告、になれますかという質問をしましたが、日本ではなれないのではないかというのが、ご見解でした。And lastly, what if Pony TV has a license only for distribution of TV program, but not for merchandising rights? Does Pony TV have standing to sue? Pony TV, who does not have a license for merchandising. In that case, Pony TV have standing to sue, yes or no? I believe everybody should be yes. No, everybody, no. はい、yes, thank you. 違うわ。Sorry, in your booklet, Vietnam answered yes. But actually, after sending these answers, she noticed that the answer should be no here. Is that okay?
Yes.
Judge?
Yeah, thank you. For the answers, I answer yes for 3 situations, but anyway, it's maybe my mistake. Because at the end of this answer, I say that's within the scope of copyrights granted. So in this situation, in Vietnam's Pony TVs cannot have a standing to suit for copyright infringement.
Thank you. 条文をご紹介いただいてて、それで一番最後の行にですね、Within the scope of copyrights granted とありますので、ここでは許諾を受けた範囲ないということからすると、これの答えはノーであるべきでしたということのようです。というわけで、regarding this question, every country says that the licensee does not have standing to sue. And even if the license is exclusive, the license without merchandising right cannot have standing to sue. So how about in Japan, Judge Tanaka?
Okay, I also think that Pony TV has a licensee not to sell, but only to distribute, cannot ask the court for injunctive relief and damages against the sale on internet by DonkeyNet, because Pony TV does not have a license to sell, which is the act of donkeynet. Thank you.
Thank you. 日本においても、認められないということです。で、ケース2に移る前にですね、私ちょっと前半の方で、言及するのを忘れたことがございます。Question number 3、に関して、ですね、お手元のその資料の中で、フィリピンの、ご回答が、図2と図3、図2と図4を、対比して、いる形でご回答されているのですけれども、先ほど壇上でお答えいただいた通り、図1と図2、図3、図4という対比にするべきでしたということで、図4が非類似であるという結論は、図1がオリジナルだとしても、変わらないということですので、ちょっと訂正させてください。それからシンガポール、同じ質問のシンガポールの回答ですけれども、実はこちらのなんか手違いがあったようで、その裁判官がお答えになる際に図1がですね、ラブだけのイラストじゃなくてナッチュンとラブが並んで描かれたイラストが図1としてお手元にあったそうで、それを前提としてご回答されているので、少しちょっと回答がそのイラストの一部がっていうような表現があるんですけれども、それはその図1がその回答を作られた時には、図1がちょっと本来のラブだけのイラストじゃなかったために、そのような回答になっているということで、回答自体は先ほど壇上でお答えいただいた通り、ですけれども、ちょっとその資料の中の、回答が親と思うような内容になっているかもしれないんですけども、そういった事情がございますので、それはご了承ください。それでは以上でケース1については終了いたしまして、ケース2に移りたいと思います。
はい、ケース2です。こちらは、事例としましては、日本のメーカーのポニー社が製造販売する犬型の AI スピーカーロボット8個というものが人気です。あなたの国で8個という名前は使われていないものの AI スピーカーロボット8個の形を模したぬいぐるみがドンキーネットで販売されていますと。ドンキーネットはポニー社からライセンスを受けていない場合、ドンキーネットの行為は違法になりますかという質問になります。事例1とは異なって、犬型の AI スピーカーロボットは漫画や、アニメなどの著作物の中のキャラクターではなく、大量生産される、商品として、開発されたもので、いわゆる応用美術に該当すると。で、この事例は各国の応用美術の保護について、お聞きする、事例ということになります。それでは、日本の当事者の主張を、お願いいたします。
Plaintiff argues as follows. Regarding question 1, whether or not so-called applied art is protected under the copyright law, the answer is yes. The primary claim in gist, hachiko is a product which has the practical purpose. However, we can see the thoughts or sentiment are expressed in a creative way from him, so it should be protected as an artistic work. Even if that primary claim was not accepted, Hachiko is still protected under the copyright law because he had an expression of beauty which can be separated from the function of his practical use. Regarding question 2, whether or not product with a practical use should be protected aside from the copyright law, in Japan, aside from the protection of the copyright law, Hachiko should be protected under the criminal law, civil law, Unfair Competition Prevention Act, Design Act, and Trademark Law as well. regarding question 3, hardcore is a mass-produced good. It's true. However, still has an expression of beauty in its look and figure, which can be separated from the function of practical use. His electrical functions, such as sounds and movement, also constitute an expression of beauty, separated from the function of practical use. Thank you.
Okay, again, Ayako Suga representing the defendant Donkinet. On question 1, the defendant agrees that generally speaking, work of applied art may be protected under copyright law if it is equivalent to fine art. Fine art is generally understood as expression of excellent beauty. In the present case, however, the speaker robot at issue does not qualify as expression of excellent beauty and should not be protected under copyright law. This leads to the defendant's argument on question 2. Obviously, the speaker robot is an utility article. The defendant argues that utility articles should be protected under design law, trademark law, and fair competition law, but not under copyright law. Extending copyright protection to utility articles in general would be too much and diminishes the purposes to have separate laws for different intellectual properties. As stated earlier, work of applied art may be protected under copyright law only if it is equivalent to fine art. In other words, if it qualifies as expression of excellent beauty. The standard applies when answering question 3. The fact that the speaker robot is mass-produced is not relevant here. What is important is whether it is an expression of excellent beauty. In other words, if it is produced to solely pursue beauty or for ornamental purposes. Speaking to the electoral functions of a speaker robot, such as its sounds and movements, if it qualifies as expression of beauty, it could be copyrighted, but in this present case, we would argue that it does not qualify as copyrighted work. For these reasons, the speaker robot should not be protected under copyright law, and the defendant asks this court to deny the plaintiff's claims. Thank you.
はい、ありがとうございました。では、日本以外の国においてはどのように判断されるのかという点を、進めていきたいと思います。まず、そうですね、クエスチョン1からですね。はい。So, let's start with question 1, which is about are works of applied art protected under copyright law in your country according to Berne Convention for the protection of literary and artistic work. And according to the answers in the booklet, in Cambodia, Vietnam, Indonesia, Myanmar, Philippines, Singapore, Thailand, it is protected. And in Malaysia, it is not protected under copyright law, but by the other law. And Laos actually didn't answer it in the booklet, so I would ask later. First, I would like to ask the judge from Myanmar. Okay. The old laws did not protect applied art, and does the new laws start protecting applied arts for the first time?
Yeah, because old laws is enacted very, more than 100 years ago, and it led to cover the current, copyright issues and challenges, including applied art. So according to the old law, the applied arts cannot be protected, but there is a specific provision in our new law. So in another new law, applied art can be protected.
Thank you. 今回の回答はすべてその新法に基づいてということになるんですが、その新しく制定された法によって、応用美術というものが保護されるようになったということです。And then next, I would like to ask the judge from Malaysia. Is applied art protected under laws other than copyright law? And could you explain the situation in your country?
Yes. Thank you. The law is not very clear, actually. There's no case law on it. I think traditionally, we have the Copyright Act in 1987, but there was a predecessor act. And artistic work has not been defined clearly. And traditionally, the understanding is that it applies to pure art. And then in 1996, we have enacted the Industrial Design Act. And with that new act having been enacted, there was an amendment made to the Copyright Act by introducing 2 sections. First being that if it is an applied art registered as an industrial design, then the Copyright Act doesn't apply anymore. Second is that if it's in the process of application and it has been distributed or utilized in excess of 50 times, then it cannot be registered, or rather it cannot be subject to the protection of copyright. So it does seem then that perhaps applied art may be protected by copyright from that interpretation of that new added section. So it's not so clear. That's why I'm saying that that is a problem we have at the moment.
Thank you. 今ご説明にあった通り、デザインに関するその法律で、保護されると基本的にはその二重の、著作権法との二重の保護というのはしないことになっていて、でかつ50以上の、プロダクトが、生産されるとそれはもう、著作権法の範疇ではないという、この点はまた後ほど、ちょっと議論させていただければと思います。で、ちなみにブックレットの方で、そうですね、いいですね、ごめんなさい。はい。で、then next Laos, that from Laos. So could you explain your country's position?
Sorry. Okay, thank you for confirm the question because I just not have the answer yet. Based on the Article 101 and Lao IP law, define that a work based on a traditional literary or artistic work shall be protected under copyright without prejudice to the rights of the other to make original works based on to the same traditional literary or artistic work, and to continue to exploit the traditional literary and artistic work. So I think that it follow the Berne Convention.
So it is protected?
Yeah.
Yeah. You apply art.
Yeah.
すみません、ブックレットの方では回答がなかったのですが、今、ご回答いただいた通り、応用美術の保護について、ご回答いただいた通り、保護があるということです。そして、そうですね。So, Judge Tanaka, so could you make a comment based on the laws of Japan?
Sure. In my opinion, also concerning this question, my answer is yes, when satisfying some requirements. Japanese copyright law stipulates that artistic works include artistic craftsmanship, but works without statutory language are applied arts. On the other hand, design law protects industrial design, so bottom line is how to coordinate protection of design law and copyright law. So I think applied arts can be considered to be protected by design law and principle. However, I think that copyright law also protects applied arts when meeting some requirements. So this can be supported by theses and case law. This is my comments.
Thank you. 応用美術についてはご案内の通り、日本においても、トリップトラップ等を含めて、そもそも判断基準に、流れというか、二分されて、大きく分けて二分されて、ちょっとトレンドが、流れがあったところですが、一定の要件を満たせば保護されるというところにおいては、今ご回答コメントいただいた通りのところです。では、クエスチョン2に。
Okay, let's move to question 2. The question is whether AI speaker robot Hachiko is protected under copyright law, even though it is not a work of pure art, but a useful article. And also, are there any other laws which protect AI speaker robot Hachiko? Andこの資料の中には AI スピーカーロボットのハチ公のイラストというか絵は入っていないんですけれども、一応ですね、こう準備されたものが実はあったんですね。これは何かどこかで見たような気がしますけども、ラブ犬バージョンみたいなやつです。はい、これを、見ながら、考えていただきたいと思います。So, again, I try to. Can you show the cars that whether the Hachiko is protected by copyright law in your country? Yes or no? Every country says yes. So I'd like to confirm, because in the booklet, maybe Cambodia and Myanmar actually answered no in the booklet. So, so first, Judge K. Manila from Cambodia, why did you change your mind?
The reason that I have changed my mind is that mainly it's because about translation of the word applied art into our Cambodian language. If you look into the question 1, the applied art is also protected under our copyright law in Article 7 and Paragraph 8. So therefore, if we consider the AI speaker robot Hachiko as a applied art, so it will also fall into the Article Article 7 and Paragraph 8, therefore it's also protected.
まずクエスチョン1のところで応用美術は著作権法で保護されますというふうに答えてらっしゃって、この8項がその応用美術アプライドアートだということであれば、ここでのクエスチョン2のここでの答えもイエスになるべきでしたということで、そこは訂正していただければと思います。So, Judge, so confused from Myanmar. I think you also, in the booklet, you answered no.
Yep, right. Thank you for the question. In the booklet, I said no. It's just based on the fact of the cases. Because in principle, the article can be protected under copyright law. But according to the fact, because our new copyright law says that there should be the official distribution of this article in Myanmar, and also one of the Myanmar citizens should be granted some exclusive licensing or something like that in order to be the right holder. So my answer no means because of the fact of the case. But in principle, article can be protected copyright law. But according to the fact of the case, no. Could you clear my answer?
Thank you. 事案に即して回答した結果、ノーにしたけれども、プリンシプル、原則としてはアプライドアートは、保護されるということです。で、So I'd like to ask Judge Lim from Malaysia. Maybe I think I'm afraid you already answered, but you mentioned that the applied art is not protected under copyright law in question 1, to the answer of question 1. But here you said that the hachiko can be protected under copyright. So can you explain your answers?
Right. I think it can be seen perhaps in two ways. One, if a hachiko is seen purely as a toy and not of industrial application, then I believe it can be seen as pure art and therefore covered by the Copyright Act of Malaysia. But at the same time, if it is actually a robot with utility functions, then, as I was saying, because of that extra provision since the inception of the Industrial Designs Act 1996, arguably, if it has not been applied for registration and not used more than 50 times by way of distribution, then it could still be covered under the Copyright Act. So that's where it's not clear at the moment in Malaysia.
Thank you. どっちとも意商法の方にアプライしていない場合ということを想定すると、先ほど見せたこういった8項は応用美術として著作物として保護される可能性があるかなということですけれども、50個以上量産されるようなものであるということになると、もう衣装法の話になってくるということですの。はい。Then, so Judge Malabagyo from Philippines. In your answer, you mentioned that the applied art is copyrightable when an artistic element of the article is separable from its utilitarian application. So, how will you decide the separability in this case, in this hachiko case?
Well, under our intellectual property code, if the artistic element can be separated from the utilitarian application, then that is copyrightable, that is protected under our laws. Now, in that case, if the shape and the arrangement of the colors could exist independently, then that is protected under our laws, and that is copyrightable. For example, if we transfer the shape and the arrangement of colors to a canvas or a wall, and it can exist independently, and that will turn out to be a two-dimensional character, then definitely that would be copyrightable under our laws. So if it can exist independently from the utilitarian aspect, then it can be copyrightable.
Thank you. 実用機能的な要素から美的な要素が分離可能であれば、コピーライタブル、著作物性がありますよということが、規定されていますということで、この例でいけば、例えば色や形といった部分が、そのアーティスティックエレメントになるのではないかということです。ちょっとだいぶはしょっちゃってるけど、そういうことです。And Judge Yeo from Singapore, you mentioned in your answer that the shape of hachiko is, if the shape of the hachiko is unique enough, then the copyright protection will be available. So could you please explain your answer?
Yes, thank you for the question. The reason for this answer was because when we were answering the question, I hadn't had a chance to see what the hachiko looked like. And so it depends, because if the hachiko is just a circle, for example, it's so simple, it's just a circle or just a square, for instance, then it is arguable that that would not be protected under copyright law. But based on what I have seen today, this dog that you are holding in your hands, I think that this would be protected by copyright.
Thank you. 実はこの図、各裁判官が回答を作成される際にもなかった手元になかったようで、そういった意味でこう見てみないと何とも言えなかったからねという部分も、とてもシンプルな形であれば、著作物性はないからねということで、こういう形であれば著作物性があるんだけれども、シンガポールに関しては、この後もう一回質問させていただ次の質問の中でご説明いただきたいと思いますけれども、意匠法と著作権法の保護が重複するかどうかというところにまた論点があります。それはちょっと次の質問の中でご説明いただくとして、応用美術の著作、copyrightability of applied art, as you may all know, that used to be a recent hot topic in Japan. Could you please introduce such arguments in Japan, Judge Tanaka?
Sure. Okay. AI speaker Hachiko is very stylish, copyrightable, I think, even though AI speaker Hachiko falls within the mass-produced utility articles. Generally speaking, our case law shows two standards for protection of applied art. The first one is when works have an aesthetic appreciation feature similar to fine art, aside from the practical utility aspects, those works are considered to be within the category of artistic works and are copyrightable. And second one is when works exhibit the individuality of the creator, those works are considered to be copyrightable. The second standard is adopted in the Intellectual Property High Court judgment 2015 that is related to a trip-trap baby chair case. That is very stylish chair that is made by the designer of Norway. And my understanding that the second standard thinks that it is not appropriate to impose special subjective requirements only on applied arts. My understanding is the distance of two standards is now relatively approaching, because from the standpoint of the first standard, aside from the the first standard is aesthetic appreciation features similar to fine arts. So this part, if this part can be decided objectively, not subjectively, I think it approaches the two standards. And also two standards, divides second standard, say that aside from functional aspects, whether there is individuality of the creator, those works are copyrightable. So that's my personal view, but I think that there are two standards in Japan, but those two standards is not totally different. But applying those standards to the AI speaker Hachiko, I think in spite of which standards to apply, the conclusion is the same. Because applying the first standard, aside from the functions of the AI speaker, Hachiko's face, ears, and color have aesthetic appreciation features similar to fine arts. And according to the second standard, AI speaker Hachiko exhibits the individuality of the creator. Therefore, I think in this case, AI speaker Hachiko is copyrightable in spite of which standards to apply. This is my comment.
Thank you. 日本では純粋美術と同視できる程度の美的鑑賞にされるような性質を持っているかどうかということ、そういう基準で判断する場合と、単純にその個性が現れていれば足りるんだという判断基準と、あり得るけれども、いずれの基準に立っても著作物性は、認められるでしょうというお答えでした。ちなみにファッションショーかなの著作物性の話題が問題になった裁判例では、分離可能性説も採用されていた、そういう裁判例もあったかと思います。フィリピンで取られてた分離可能性説に近いものが判断基準として示されたケースもあったかと思います。Okay, then let's move to the next question. Then I ask the availability of the other law protection. I mean the laws other than copyright law. So to simplify, just again, let's try to use this one. Can Hachiko be protected by industrial design law in your country? Can Hachiko be protected by industrial design law in your country? Yes or no? Okay, every country says yes. So actually, in the booklet, the Cambodia, Myanmar, Laos, Vietnam, it seems that they didn't refer to the industry design law, but actually all of that those countries industrial design law protection will be available. So please note that these countries also applied art can be all protected. This kind of Hachiko can be protected by industrial design, right? So then the next question is whether the dual protection, the protection by industrial right, design right, and copyright, both protection are available at the same time. Yes or no? The Hachiko can be protected both by industrial design right and also a copyright. Yes or no? Dual protection available? Yes or no? So, thank you. Singapore and Myanmar no, says no. So, Malaysia は違った。It depends. Okay. So Judge Yeo from Singapore, maybe it's your time to explain your Singapore system. Could you introduce your country's system?
Okay, so under Singapore law, dual protection under copyright law and registered designs has been reduced to a minimum. Essentially, I can elaborate on two possible scenarios. So where you have a copyright artistic work that is registered under Registered Designs Act, then copyright protection doesn't apply anymore. You will only get the protection under the Registered Designs Act. And this is an important difference to the owner of the copyright because the length of protection is different. For copyright, you have 70 years after the life of the author. Whereas under the Registered Designs Act, you have 5 years protection at first instance, and you can apply again and get another 5 years, and one more time to get another 5 years, so a total of 15 years under the Registered Designs Act. So once you register your design, you lose your copyright protection, you have registered designs protection. That's the first scenario. The second scenario is where your copyright work could be registered, but you did not register it. And in the meantime, you industrially apply your copyright work. So you mass produce 51 copies of your copyright work. In that situation, because you have not registered, and yet you have industrially applied your design, you lose your copyright protection, and you also do not get your registered designs protection. So this whole scheme is designed to make sure that whoever wants to industrially apply his work will go and register it under the Registered Designs Act. Thank you.
Thank you. 2つの場面についてご説明くださいまして、まず遺書権を出願して登録されたら、その時点でもうコピーライトプロテクションはなくなりますと。で保護期間が違いますので、遺書権については5年を2回更新してマックス15年ということのようですけれども、もうその遺書権を出願して登録になったら遺書権のその15年の保護期間でプロテクションは終わりと、コピーライトのプロテクションはもうなくなりますということ。それから2つ目のシナリオとして、本来遺書権を登録できるのにそれをせずに、大量生産品を、いわゆる、プロダクツを作った大量生産の製品を作った場合は遺書権も当然登録してないので遺書権のプロテクションはないんですけれども、コピーライトのプロテクションも失いますということです。要するに、大量生産した時点でもうそれは本来遺書権登録すべきものだったということで、それはもうコピーライトで保護するもんじゃないよねという判断になるということなので、この点は非常に面白いかなと思います。Then, so I'd like to ask you whether Hachiko can be protected by. ちょっと待って。Sorry. Myanmar says that also dual protection, no dual protection. So can you explain your system?
Yeah, in my booklet, in my answer, I said that the Hachiko cannot be protected under industrial design law. It is just based on the fact of the case, not in principle. So in principle can be protected, but according to the fact of the case, there is no registration. I assume that's why I say that it cannot be protected under industrial design law. And there also no dual protection, because industrial design law says that the infringement happening under this law, the industrial design law, the governing law will be only the industrial design law. So, for example, I'm an owner of this Hachiko, so I register my Hachiko under design law. Then, if infringement happen, the governing law is only the design law. This means that it can be protected under copyright law, it can be protected under trademark law. But I register under the design law. It says that I release my protection under copyright law. I jump into the industrial design law to be protect my product. So no dual protection. If I register, then this infringement can be decided only based on the design law.
Sorry, let me clarify that. So if the scenario 2, Judge Yao mentioned that if you didn't file an application for design right, then and the product is mass produced, what happened? Is it, of course, you didn't file an application, so the design law protection is not available. But in that case, copyright protection available?
Yeah, if no registration, the hachiko can be protected under copyright law. But in our copyright law doesn't say anything about the mass production. So it's no registration, no protection under design law, but can be protected under copyright law.
Okay, thank you. なるほど。まあ、意思権登録したらもう意思権登録だけが生きるけれども、まあ、もし意思権を出願せずに、しなかった場合はコピーライトの方が生きてくるということで、まあ、同時に2つの権利の保護は受けられない。意思権が生きている間は意思権が効きますよというのがミャンマーの、立場だということです。So, I'd like to confirm that hachiko can be protected by Unfair Competition Prevention Act in your country. Is just simply show this Unfair Competition Prevention Act will apply to this hachiko, yes or no? Cambodia to Myanmar, Laos, Thailand, Philippines, and Vietnam. Okay, thank you. So those countries also have the possibility to be protected by Unfair Competition Prevention Act. So could you please explain the situation in Japan, Judge Tanaka?
Sure. I think that AI speaker hachikos, a trademark, okay. I think that AI speaker hachiko shapes and cards have a possibility of being protected under design law, unfair competition law, and trademark law when meeting each law's requirements. I think trademark law protects three-dimensional trademarks such as the bottle of Coca-Cola. Well-known shapes are also protected by unfair competition law. Even if not well-known, identical imitation is also prohibited by the unfair competition law in 3 years. So, and they are also protected by the design law as an industrial design. That's my comment.
Thank you. じゃあすいません、残り時間少ないので3番に行きます。
So let's move to question 3. So actually we are running out of time, so I would quickly cover this question. The question 3 is about mass producing and the function of movement and the sound. So question 3 is number 1. Is the shape of the AI speaker robot hachiko protected as work of applied art, or is it protected as work of pure art under copyright law? Is there any classification between the pure art and applied art? Regarding this question, in Vietnam and Indonesia and Philippines and Thailand, it would be protected and as applied art. And in Laos, there is no specific classification. And it seems Singapore says that there is no specification. And in Malaysia, as early mentioned, Industry Design Act would be applied, so not by the copyright law. Okay, so I would like to ask Indonesia, the judge from Indonesia, how do you distinguish from the pure art and applied art? What is the definition?
Yes, thank you. Well, is probably, I don't know whether it exists in any other system, but if within Indonesia, usually when you enact such an act, there will be the official translation, and I believe also in China there will be the interpretation, but there will be interpretation is a long way, but there is the official interpretation of what is said to be the applied art. As I said, the term of the work of applied art means a fine artwork created by applying art to a product that has an aesthetic impression to fulfill practical needs. So there is a definition in Indonesia.
Okay, thank you. So let's move to question 3, number 2. What if hachiko is mass-produced? Would it be protected under copyright law? So with respect to this question, in Vietnam, Indonesia, Laos, Philippines, Thailand, it would be protected. And on the other hand, in Singapore, if it's produced, mass-produced, it would not be protected. So I would like to ask Singapore. So as you mentioned earlier, there is prevention for the dual protection among copyright and industry design law. Is there any definition of mass production
Yes,
in your country?
There is, and the definition is that if you have more than 50 reproductions of this particular article, then that's mass production. There is another aspect of the definition, which is in relation to articles that are not that are manufactured in lengths. For example, a whole length of wallpaper, in which case, as long as you produce one such article, that could be application, industrial application.
Thank you. And then Malaysia. So I assume that the concept is very similar to the Singapore's, but
yes,
so
it looks like we share the same provision.
Yeah, so there is the same standard for mass production, right?
Yes,
50.
that's correct.
50という複製の50という基準が法律上そもそもあるというのがかなり特徴的なところかと思います。そして、then question 3 is number 3. What if hachiko has a function of sound and movement, electric function? Such hachiko can be protected under copyright law. And regarding this question, in Vietnam, Laos, Malaysia, Philippines, and Singapore said it can be protected. And so among those countries, I would like to ask Philippines. So you mentioned earlier that there's a separability standard. So you would apply the standard to this question, right?
It would apply.
Yeah. So
same application.
Yeah, separability. And so you think that the such function, the functional aspect, would be or not protected?
It will be protected.
Will be protected.
It's the same.
Okay. So and okay, then Thailand. So could you briefly explain your position regarding this question? I mean, the product which has a function of the movement and sound.
Yes, because I would like to explain like this. Industrial design is part of the patent law in my country. So if you have a functional issue, you will be protected by patent law. But for the industrial design, we just looking for the shape, not a functional issue.
Okay.
So if there is a functional issue, they will be protected by the patent law.
Okay, thank you. Then Judge Tanaka, could you briefly explain?
So, briefly comment. AI speaker hachiko shapes, colors are copyrightable, even though AI speaker hachiko has motions and flashing lights or mass-produced utility articles. I think that if motions and flashing lights do not consist of essential characteristics of hachiko, according to the separability doctrine that I omitted before, I think that those electronic functions can be successfully separated from hachiko's expression, ears, and color. The Sendai High Court case precedent in 2002 rendered judgment relating to Fervidor, pointing out that these electronic functions undermine aesthetic creativity. However, I think that the facts are totally different. The Fervidor is for amusement, so it is difficult to separate utility functions from Furby's expression. Compared with that, Hachiko is just an AI speaker, so I think those AI speakers' functions can be separated from Hachiko's expression. That's my comment.
Thank you. それでは、もうすでにタイムアップと言われてますので、これで午前中のパートを終了したいと思いますけれども、ケース1ではですね、キャラクターの著作権による保護の可能性について議論しまして、結論が大きく異なる国というのは実はそれほどなかったかなと思いますし、特にそのネットショップのサーバーが国内にあることが必要になるかどうかという点について、その国内向けに必ずしもそれは必要じゃないんだという国の方が多かったということも非常に重要な知見だったかなと考えております。ケース2については応用美術の保護の可能性ということで、なかなかちょっと議論を深めるのも難しかったんですけれども、シンガポールやマレーシアなどですね、50個以上生産するともう何もなくなっちゃう、一生懸命出願しないでおくと何も法的保護がなくなるというようなことを、そういった各国の制度を正確に理解しておくということが非常に重要かなと考えております。で著作権というのは登録を必要としない権利ですので、ASEAN における、キャラクターやそういった、著作物の保護の可能性を知るというのは実務上も非常に有益であると思いますので、本日の講義がその今後の、保護可能性の検討の一助となれば、幸いです。最後に登壇された各国の裁判官の皆様、そして弁護士の皆様に盛大な拍手をお願いします。
登壇者の皆様、ありがとうございました。以上をもちまして民事パート模擬裁判を終了とさせていただきます。